as we just heard, Trump is getting his day in court, and his former chief of staff was in court today trying to get his case out of the state of Georgia.
That's right. Former North Carolina Congressman Mark Meadows wants to have his charges in the case of election interference moved to federal court, and he argues he was simply doing his job as a federal employee. Now, here to talk about it, if those claims hold any kind of weight, here is Queen City News Chief Legal Analyst Khalif Rhodes.
All right, so Khalif, does Meadows actually have a chance of getting this moved?
Well, there's always a chance. Obviously, you can make a novel legal argument. I always tell my clients, when you have an opportunity to present it in front of a judge instead of a jury, the judge can go 50-50, and the case law is there for him to be able to have it removed or not. But I think we first have to look at what removal is. It's taking it from the state court where this was filed, Fulton County, and taking it to federal court. That process is something that's really old. It dates back to pre-Civil War time, for when the Union states were trying to enforce their laws, and Southern states were trying to actually prosecute Union officials, and they were like, well, these are federal charges, you can't do that. And so I think it's a novel kind of historic lesson that now folks that are charged with federal crimes were trying to get their cases removed to federal court, and these individuals are trying to say we were actually just doing our federal job. For him to be able to get it removed, he has to say that he was within his office, and that's going to be a stretch for him to be able to prove, because not only does he have to be in his office, he has to point to a defense that's a federal defense, something that would have protected him for doing that job. And today in the hearing, that's what the DA said. She's asked him on cross a number of times, can you point to, can you direct me to what federal law would protect the actions that you were doing, specifically going to Cobb County and watching them count votes? He said, well, I was in the area. I was just down there. I know the president was going to want to talk about what was happening in Georgia, and so I proactively went there. I think there is going to be a couple of issues with that line of questioning from the judge and his answers and response. Also, he seems strong, is what most reports are saying, in terms of very adamant about, I was only doing my job. And so we shall see.
But yeah, and we're waiting on that news to drop at any moment now. If it does happen, we will certainly let you know. But what does it mean for the case itself? I mean, any kind of delays, or also as far as cleaving off some of the people out of this RICO case? It's
a really good strategy in terms of jury pool. I think that's the best place I can start. In Fulton County, obviously, it's a purplish blue county for sure. You're talking about the Northern District of Georgia, which is more red. I mean, it's way south of Fulton County. And so you have I won't say MAGA Republicans, but a strong history of Republican-based voting bloc. And so that pool would be strategically a lot more favorable to the president, and in turn more favorable to Mark Meadows. I think that's the first place you start, is ensuring that I have a voter base, or I should say a jury pool, that will be sympathetic to my argument.
And I think this would be highly dependent on what a judge decides here. But do you think any of Trump's other allies who are indicted in this case might say, like, hey, I want to try something similar to get this case moved out of Georgia, and would that benefit them? I
think that's a good strategy. Some folks, it for sure won't be applicable. And it's not only for elected officials or federal officers like Mark Meadows was his chief of staff. It also would apply to, like, contractors. The courts have held, if you're a federal contractor, as long as you were under the direction and under the supervision and were acting under the authority of a federal official, then you also can use this same rule. So a couple of those individuals would qualify for that because they were acting under the authority. Philip Morris tried it a few years ago, back in 2007. They wanted their case removed, and they said, well, the FTC, the Federal Trade Commissions, were acting under their authority. The court didn't believe that. They said, no, you were acting on your own. Your case will stay in state court. I think it will be a case-by-case basis to see who will actually get their case removed and who won't. But I think Meadows' case is ripe as long as he can actually point to doing something that was covered under federal law. And I'm not sure if he's able to do that yet.
Well, we shall see on this decision coming down here very soon. Chief Legal Analyst Khalif Rhodes, thanks for breaking it down for us.